Thank you, Mr. Speaker. I'm very pleased to rise again on Bill C-23, an act respecting the pre-clearance of persons on goods in Canada and the United States. Back in 2011, when our former Prime Minister Stephen Harper and former President Barack Obama announced the Beyond the Border Declaration, a shared vision for perimeter security and economic competitiveness. This declaration...
The honourable member for Flamborough-Glanbrook on a point of order.
Speaker, my honourable colleague is just 3 seats from me, and it's absolutely impossible for me to hear him with all of the din over here. I'd ask the members to respect their colleague and please quiet down and come to order.
Well, I thank the honourable member for Flamborough-Glanbrook for his intervention. It seems to have had the desired effect. And we'll continue with on debate on Bill C-23. The honourable member for Yellowhead.
Thank you, Mr. Speaker. Thank you to my colleague next door. I was having a hard time to figure out where I was going with that. Now I've lost myself again. That declaration had deepened cooperation at the border between Canada and the United States. It gives us an opportunity to exchange best practices. We have successfully launched the automated biometric-based system and counter identity fraud, and we signed a historic agreement on land, rail, marine, and air transport. Mr. Speaker, we have Nexus. A Nexus is a very simple process to speed the movement of people across the borders from Canada to the United States and vice versa. And I'm a very proud Nexus card carrier. I think we got close to 1.5 million people in Canada with Nexus cards, and it really streamlines the movement not only in Canada, but going into the United States and back. Except, last year I went on a holiday, Mr. Speaker, and I went to Mexico, and I had to go through customs in the United States. There was a long line of people. My wife pointed to me and says, hey, there's the Nexus line. There's nobody there. We have Nexus cards. So we went through. She went through just as slick as could be. I had problems, Mr. Speaker. I put the wrong information in. The lights shone, everything stopped. And by the time I answered the right questions, verified who I was, corrected the mistakes I made, Mr. Speaker, I got through. It took about 45 minutes to an hour. My wife looked at me. She was very mad. I'm not sure why. Then I looked over at that other line that was really long, and we didn't go through. We're already gone. And I was the last person standing going through security. And I'm bringing that up because it was mentioned in this House by some of our opposition members to my left, not across, but to my left, that their people are having problems and that the border guards being given the extra authority under this great Bill C-23 are imposing problems. Most of those problems become mistakes, either by the individuals going through or by their body motions or their suspicions that they might be putting through our security guards. And I think it's very important that our security guards, whether they're Canadian working on the U.S. side or Americans working on the Canadian side, if they have reasons to believe, due to suspicious activity by that person or persons trying to go through the border thing, that they should be able to detain them, to question them, to see what's actually going on with them. They can't hold them, but they can turn them over to Canadian officials because they are doing those security checks on Canadian land and are subject to Canadian laws. Thank you, Mr. Speaker. I think that's just...
Questions and comments? Questions et commentaires? Honorable secrétaire parlementaire de la leader du gouvernement à la Chambre.
Yes. Thank you, Mr. Speaker. And I think, and I appreciate the comments from the member across the way, and recognize this is good news legislation in the sense that millions of Canadians benefit every year through pre-clearance, and I appreciate the story that the member across the way has put on the record. And at the end of the day, Canadian and Canada as a whole benefits by pre-clearance, and it's important to recognize the economic value of this, whether it's to our tourism industry or even with a product, Mr. Speaker, and the potential going forward into the future is really encouraging. My question to the member is just recognizing the fact that the legislation itself deals with pre-clearance, meaning that if these are individuals and the merchandise going before they arrive in the U.S., they can actually get pre-cleared, which allows them to ultimately fly to many other jurisdictions in the U.S., otherwise in which they would not have been able to do that if pre-clearance did not exist. We do not see that as a very strong thing, and we should continue to move forward on that front.
Honourable member for Yellowhead.
I'd like to thank the member across for that question. Yes, he is absolutely correct. It is going to speed things up. And this isn't anything new to Canada. I think I mentioned in my speech last week about CanPass, which was a pre-clearance for small private aircraft flying to and from Canada. You give your information beforehand, an hour before you cross into the U.S. border. That information's already there. They know who's arriving, where they're coming from, where they're going. You go there, in a few minutes, you're gone through the customs check. Before, it used to take us lots of times well over an hour. This is going to speed up trade and commerce between Canada and the United States, and it's a good thing. Thank you.
Questions and comments? Question commentaire. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker, and I thank my colleague for his excellent speech, both previously when this bill was debated and continuing today. Now, we've heard some concerns about this bill in terms of the protections that might exist and people raising concerns about the way in which screening happens in the United States. But it's important to underline, of course, that the screening that takes place and why we're supporting this bill is the screening that takes place is going to be on Canadian soil. It's subject to Canadian law, Canadian human rights protections. And also, it provides people with better opportunities to leave that situation if they maybe don't like what's going on, opportunities that wouldn't exist if they were perhaps being screened on the other side of the border. So this bill, it facilitates commerce, it facilitates travel, but it also provides for effective protection of human rights. I wonder if the member could comment on the advantages that come with this legislation and how it continues the good work begun under Prime Minister Stephen Harper.
Honourable member for Yellowhead.
Thank you, Mr. Speaker. And through you, Mr. Speaker. Yes, he's very correct in the fact that giving the U.S. border guards that are working on Canadian soil to pre-screen Canadians going to cross into the United States, they have to do it according to the laws of Canada. So the people going through that are being maybe held back a little bit for a little bit of extra questioning are being held back using Canadian law. So that's good. No one is going to be able to abuse the system. There are rumors out there that they're going to have the power to detain and hold Canadians. That is not correct. If there is some suspicions that may lead them that way, they have to call Canadian authorities who will then do that process, Mr. Speaker. But it will be good to expedite travel between Canada, United States, and trade. Thank you.
Now we have time for one more question. Questions and comments. Question commentaire. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable colleague for his speech. I don't think anyone objects to the notions of pre-clearance. They're working fine currently, and the concern is why the additional powers for U.S. officials to, for instance, be able to hold someone who's decided they no longer want to cross in the U.S., hold them for further questioning, continue to keep them within the jurisdiction of that pre-clearance U.S. space. And can he explain why we need more pre-clearance powers to U.S. officials than those they have now?
Honourable member for Yellowhead.
Thank you, Mr. Speaker. Mr. Speaker, if a person's acting suspicious, whether you're at a border or whether you're at a road check on the side of a highway and you're pulling people over for impaired driving, and somebody drives up and turns around and takes off, the police officer should be suspicious enough to follow that person. Because if he didn't, that person's probably guilty either of impaired driving, maybe a crime, maybe he's trafficking in drugs or something like that. So due diligence of following through is good police work. Due diligence at the border, if someone's acting in a very suspicious nature, they're very nervous, they turn around and they leave, that border customs officer doing due diligence to protect the rights of Canadians should stop that person further and check and just see what the reasons are why that person does not want to go through a border control thing. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Oakville North Burlington.
Thank you, Mr. Speaker. I'm pleased to rise to discuss Bill C-23, which will allow for the expansion of pre-clearance operations. This is the system that for over 60 years has allowed travelers in Canadian airports, currently Vancouver, Calgary, Edmonton, Winnipeg, Toronto Pearson, Ottawa, Montreal, and Halifax, to go through American customs and immigration procedures in Canada. It saves travelers having to wait in long customs lineups once they arrive in the U.S., It enables direct flights to U.S. airports that otherwise only accept domestic travel, and it allows Canadians to undergo American border procedures while under the protective umbrella of Canadian law and the Canadian Constitution. This arrangement, which is currently in place in 8 of our airports, has been an overwhelming success for ordinary Canadians as well as for Canadian business. Recently, the Minister of Public Safety told the House, and I quote, 400,000 people move back and forth across the Canada-U.S. border every single day, and $2.4 billion in trade move back and forth across that border every day. We have to make that border secure, and we have to make it efficient for the movement of people and goods, end quote. Listening to the debate on this bill, it seems that there's widespread agreement among honourable members that pre-clearance is a good thing, and I'm glad to hear that. However, I've also heard members of the NDP and the member for Saanich Gulf Islands say that while they're in favour of pre-clearance, they want it to continue under the current legislative framework, and they don't understand why new legislation is necessary. I've also heard from constituents who have expressed concerns about the bill because of misinformation they've heard, so I appreciate this opportunity to explain it. The short answer is this: if we stick with the current legislative framework, we remain stuck with the current pre-clearance locations with no opportunity to expand to other locations like Billy Bishop Airport in Toronto, Jean Lesage Airport in Quebec City, Montreal Central Station, and Rocky Mountaineer in Vancouver. If, on the other hand, we want more Canadians in more parts of the country to reap the considerable benefits of pre-clearance, including more convenient travel to and trade with the United States, the way to do that is to pass this bill. And in my opinion, the most important thing to bear in mind is this: Canadians will continue to travel to the U.S. whether or not we have pre-clearance. However, with this pre-clearance legislation in place, U.S. officers must exercise their duties in accordance with Canadian law, including the Canadian Charter of Rights and Freedoms, the Canadian Bill of Rights, and the Canadian Human Rights Act. Ports of entry within the United States have none of these safeguards. Without pre-clearance service at Toronto's Pearson International Airport, it couldn't offer direct flights to almost half of its destinations in the United States because those airports don't have customs and immigration facilities. With pre-clearance, it has direct flights to 50 U.S. airports as opposed to only 27 if pre-clearance didn't exist. Pre-clearance operations necessarily involve 2 countries, in this case Canada and the United States. Therefore, any expansion requires both countries to agree. That agreement has been reached. It's called the Agreement on Land, Rail, Marine, and Air Transport Pre-Clearance, and implementing legislation must be passed in both countries in order for it to take effect. The United States adopted their required legislation last December, with unanimous support from both houses of Congress. The Canadian legislation needed to implement the agreement and expand pre-clearance is the bill before us now. Here is the choice we are faced: pass Bill 23 and open the door to pre-clearance in new Canadian locations, new modes of transport, pre-clearance of cargo, and Canadian pre-clearance in the United States, or don't pass C-23 and achieve none of that. Given the tremendous upside of expanded pre-clearance, there would have to be something really terrible about this bill to justify denying Canadians the economic and travel benefits it would bring. And certainly the reaction from the NDP and the Green Party about the provisions laying out the authorities granted to U.S. pre-clearance officers gives the impression that C-23 is the worst bill we've seen. But, Mr. Speaker, when you read those parts of the legislation, they're frankly moderate and reasonable, and quite similar to the legislative framework already in place. For example, under existing law, U.S. pre-clearance officers can conduct frisk searches. Likewise, under C-23, U.S. pre-clearance officers can conduct frisk searches. Under existing law and under C-23, a U.S. pre-clearance officer may detain a traveler if there are reasonable grounds to believe that they've committed an offence, and the traveler must be transferred as soon as possible to Canadian custody. Under existing law, a pre-clearance officer may detain a traveler for the purpose of a strip search and must request a Canadian officer to conduct the search. Likewise, under C-23, a U.S. pre-clearance officer may detain a traveler for the purpose of a strip search and must request a Canadian officer to conduct the search. The only difference here would be that a U.S. officer could conduct the search themselves in the very unlikely event that a Canadian officer is unavailable. In the existing law and in C-23, the provisions governing use of force by American officers is virtually identical. The provisions laying out the penalties for lying to or obstructing a pre-clearance officer are exactly identical. And neither the existing law nor C-23 confers any powers of arrest whatsoever on U.S. officers in Canada. Moreover, under both existing law and under C-23, travelers would be free to withdraw from the pre-clearance area. The only change would be that a withdrawing traveler could be required to say who they are and why they're leaving. The intent here is simply to address the problem of entering pre-clearance areas to probe for weaknesses in border security before withdrawing undetected. With regard to arming, U.S. pre-clearance officers would only be permitted to carry the same weapons as Canadian Border Services officers in the same environment. In other words, since Canadian Border Service agent officers don't carry firearms in airport terminals in Canada, neither would their American counterparts. And by the way, this provision, like the entire pre-clearance agreement with the United States, is reciprocal. That means that if Canadian pre-clearance officers eventually begin conducting operations in the United States, they will similarly be allowed to carry the same weapons as American officers in the same circumstances. So this isn't, as some have styled it, a ceding of sovereignty. Rather, it's a mutually beneficial agreement that confers the same authorities and obligations on both parties. And above all, as I mentioned earlier, Mr. Speaker, U.S. pre-clearance officers operating on Canadian soil will have to conduct themselves in accordance with Canadian law and the Canadian Constitution, including the Charter of Rights and Freedoms. To put that in practical terms, a traveler flying today from, for example, Billy Bishop Airport to New York has to submit to U.S. border procedures after landing in the U.S. with no Canadian legal protections. With C-23 in place, that traveler could be processed by U.S. officials while still in Canada. If you're a person concerned about how you might be treated by American border officers, wouldn't you rather undergo questioning and searches under the umbrella of the Canadian Charter protections rather than fending for yourself in the terminal at Newark? Mr. Speaker, I appreciate that it is the role of the opposition to put legislation through the ringer, and I certainly don't begrudge them their right to raise concerns and vote against the bill if they so choose. But we're talking about a measure that will bring tremendous benefit to Canadian travellers and Canadian businesses. And the worst criticism the NDP can muster is that a person who wants to leave a pre-clearance area may have to say why. To me, that seems an odd hill to die on. For my part, I'll be supporting this legislation and looking forward to the advantages of expanded pre-clearance. I encourage all honourable members to do the same. Thank you, Mr. Speaker.
Questions and comments? Question commentaire? The honourable member for Cowichan-Malahat Langford.
Thank you very much, Mr. Speaker, and I appreciate my honourable colleague's speech. Frankly, I think she's falling into the same trap of misrepresenting our position. No one within the NDP has said that we're against pre-clearance. I've used pre-clearance. It certainly helped me get through the Vancouver airport to United States destinations. We know it works. It works as well as it currently does. I have yet to hear a convincing argument from that side of the House as to why provisions in Bill C-23 to give U.S. Customs and Border officials the right to carry firearms, I have yet to hear a convincing argument in favor of that. And as respect to the concept of sovereignty, sovereignty is a precious thing, and when you start setting precedents and slowly giving it away, it makes it easier in the future to institute new forms. So my question to the honourable member is, why do U.S. agents on Canadian soil need to carry firearms? Why can we not rely on our own police forces who have sworn an oath of allegiance to the Crown to do that very same work? I have yet to hear a convincing argument for that fact.